It actually says that, yeah. It's actually pretty tough to get around it. It's there. It really took quite an effort for the Supreme Court to find a way to read an amendment that talks about probable cause and warrants to mean that you need neither. And they did that in Terri v. Ohio. Now, you see, Terri v. Ohio is a case that's hard to disagree with. It's part of the problem you always face, because it was a case where officers wanted to pat down people, but they didn't have probable cause. They needed it for their safety. That makes a lot of sense to me. And maybe we should have amended the Constitution, have a nice, clear reason for it. But instead, what the Supreme Court said in Terri was that this would be a single exception. And what they did is they decoupled the Fourth Amendment right along the bridge of the clauses. They took the reasonableness reference and they separated it from the warrant and probable cause reference and said that you could have reasonable searches or you could have searches that required warrants. Once they decoupled the two clauses, then we were doomed. Because what happened is that the court actually said, this is sui generis. It's a fancy Latin term for it's unique. You can use that with your loved one. Say, honey, you're sui generis. And that's quite romantic for lawyers. But they said it's sui generis that we're just doing it here for the officer's safety. Well, of course, what happened is the minute we crossed that Rubicon, we had an explosion of reasonableness exceptions. And now more searches are done in this country under a standard of warrantless reasonableness than under a warrant. And so we've had this rapid decline where bank accounts, telephone records, international transactions, open fields, special needs, exigent circumstances, car searches, roadblocks, they're all under reasonableness now, and the list is expanding. The court loves it. The Supreme Court loves reasonableness. You know why? Because they just sit there and they decide what they think's reasonable and not. And they a lot of times find it's perfectly reasonable, even when the original reason is no longer there. I mean, for example, they said that you could search a car without probable cause. Now, the reason they did that in the Carroll case was because they said, look, the officers can't go and get a warrant when they stop the car they think is a bootlegger. They've got to look in the car. Okay? Now, originally that was with probable cause to search the car. See, later they began to relax that. But the interesting thing is, even with probable cause, the whole reason was they couldn't get a warrant. Today, you can get a telephone warrant. In 2 minutes, you can get a telephone warrant. Virtually every jurisdiction has a telephone warrant system. So the original purpose of Carroll no longer exists. And this was actually raised to the court and said, you know, what you cite is no longer the problem. The officers can get it right there at their cruiser. And the court still said, yeah, we know that, but now we think it serves other unnamed purposes. And so we continued the rule. The reason you don't have a privacy protection for pen registers on the numbers that you dial or the stuff that you give to the bank is because the Supreme Court said that you got to give that to a human operator. Operator clicks in the number. You can't have any expectation of privacy in that. Well, of course, the problem now is that we don't have those operators anymore. You don't have those Lily Tomlins sitting there, you know, okay. It's a computer. And in fact, most people do their transactions on computers. So the original reason's not there. Doesn't matter, the Supreme Court said. It's still open for warrantless surveillance. So the Supreme Court is not going to be a help. The Supreme Court is, this court particularly, is not a particular defender of civil liberties or of privacy. So the question is, what can we do? Does it matter? What matters? And what it takes is for us to have the courage and the commitment to make a change, to call for congressional hearings, In one hearing, I even called for a constitutional amendment on privacy. Let's just put it in the Constitution and stop monkeying around. The problem is we may need a constitutional amendment if we've got any hope. We've lost so much that we would need a seismic event like that to preserve privacy. Now, some people do care. There are brave legislators in Maine that refuse to do the national identification card. And there are legislators around that have the courage of their convictions. But what I'm really afraid of is not just that privacy is going to be lost for my children, that they won't know what privacy truly is in its original form, in its unadulterated form, but that privacy will become just one more privilege of the rich. It'll become a commodity. You know, Phyllis McGinley once wrote that privacy has always been the mark of privilege. In each civilization, as it advanced, those who could not afford it chose the luxury of a withdrawing place. Most citizens don't have that luxury. They don't have a withdrawing place. And in fact, the withdrawing places are getting fewer with all of the new surveillance techniques and all the new powers. So that privilege will become just one more privilege of the wealthy and the few. If that should happen, we've changed in a fundamental way that I don't think we can imagine what we will be in the end. Because unfortunately, privacy is one of those things that you don't appreciate till it's really gone. And when it's gone, it's pretty hard to get it back. And so I want to thank you very much for allowing me to speak to you today and the honor to attend this conference. Thank you very much. Sure.
What do you say, and I'm sure all of us have this question put to us, or actually it's a statement. My friends always say, Howard, if you got nothing to hide, what's the big deal? I mean, we constantly, I'm sure you get that all the time. How do you respond to that?
I say Romania. That is, what you should look at is, you know, the Romania, Ceausescu's regime, had cameras at every single corner. Most of them didn't even work. But the fact is that people became robotic, that people don't really appreciate the things that they don't want to be filmed until they're being filmed. Suddenly, when you have companies that are saying that they're going to fire people for political activities or for embarrassing things, you know, they might not be willing to take a leaflet in the street. They don't want to be on film talking to somebody who's leading a protest or listening to a protest. They don't want to be seen going into a particular establishment. Suddenly you become aware of what you're doing and how you're doing it. Not only does it give us all a collective neuroses, but it has a corrosive effect on all the other liberties of free speech and free association. And unfortunately, what all you can tell them is, you know why you can ask that question? Is because you've never had to make the decision. Go to Romania. Go to a place where people have to live like that. See how happy they are.
Hi.
Hi.
I'm David Henderson. First of all, I just want to compliment you on your speech, and you could almost do stand-up, or maybe the almost should be gone from that word. And second, another compliment, I saw Ron Paul interviewed a number of times, and I've forgotten who the interviewer was, but it was one of the few serious questions he got. And it was, if you were president, whom would you think of? Who would be in your shortlist for Supreme Court? And he said Jonathan Turley. And now I see why.
Thank you very much.